Turning now to the death penalty case in South Carolina and the legal issues surrounding it. Today, for the first time in 15 years, a man was executed by a firing squad. Authorities gave Brad Sigmon, convicted of killing his ex-girlfriend's parents, 3 options on how to die: firing squad, the electric chair, and lethal injection. He chose a firing squad, despite it being considered cruel and unusual punishment in some states. I'm joined now by Jessica Levinson. She's a CBS News legal contributor and Loyola Law School professor. So, Jessica, how is this an option that he could choose, and why isn't it cruel and unusual?
Well, it's an option that he could choose because some states, about 5 states, allow it to be an option. In some states, it can't be the primary option. In some states, you have to show that there is essentially a problem with another method, like lethal injection. But as I read the current Supreme Court case law, it does not ban a firing squad. It lays out standards all the way up until recently in 2019, when the court said as long as it doesn't create, meaning an execution method, a substantial risk of harm more than the alternative or a substantial risk of severe pain, then it would not be considered to violate the 8th Amendment's prohibition against cruel and unusual punishment. So
is that how Idaho, my understanding is that in Idaho, there's a bill that says this is the only way we're going to do executions, which is different than South Carolina, which said this isn't cruel and unusual because the prisoner got a choice. By your definition of the Supreme Court, it doesn't matter. Choice doesn't matter. It just matters that standard you just articulated. Is that right?
Well, certainly there could be a challenge that says when you don't have an option, then this does amount to cruel and unusual punishment. I will say that you need a Supreme Court that's amenable to that particular argument. And as I read the precedents, it's not hinging on, as your question correctly laid out, the availability of options so much as whether or not this is comparatively more, for instance, painful than other options.
In this specific case, it took 25 years. He was on death row for 25 years. What goes on during that period of time? I mean, that seems like because he admitted he'd done the crime. So what took 25 years between then and now?
So, or I'll just zoom out and say what takes so long in the vast majority of death penalty cases, where we sometimes do look at 10 years, 20 years, a quarter century, because this is the most serious thing that the state can do to an individual. It's not taking away their liberty, it's taking away their life. And so when it comes to death penalty cases, we allow people every available appeal, every available argument that even if they say I did it, that there are mitigating factors that would take, for instance, the death penalty off the table. So the short answer is because we want to provide people with as much process as possible before we take that final step.